Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Mark Erickson. Mark is a family law attorney, and his firm is located in Campbell, California. He graduated with a JD degree, that's a law degree, from Santa Clara University School of Law in 1979. He was admitted to the California State Bar and U.S. District Court, Northern District of California in 1979. After working for another attorney, mostly in the areas of civil and business litigation from 1979 through 1984, he founded his law firm in 1985. He became a certified family law specialist by the Board of Legal Specialization of the State Bar of California in 1987. He has lectured and presented seminars for many groups, including as a teaching assistant and guest lecturer at the Santa Clara University School of Law. And Mark has two adult sons, and one of his sons is also a lawyer and has been working with Mark for 4 years. So congratulations with that, Mark. So we have some additional past interviews with Mark about divorce-related topics. They're posted under past episodes at our website, financialinsiderweekly.com. So you'll actually find it's quite a resource for divorce-related topics. Today we're talking about basics of child custody issues related to divorces in California. This is a complex area of law for which you should consult your own attorney. Divorce laws vary among the states. So Mark's a California attorney, I'm a California CPA, and so some things can vary from state to state. So get your own legal counsel, please. Mark, thanks for joining me today.
Thanks for having me.
Okay. So how are child custody matters settled in divorce proceedings?
Well, I guess there are two ways. One is people reach an agreement.
That's a nice way, then.
Yeah, like any dispute. And of course, the court is there for people unable to reach an agreement to make court orders on child custody and visitation rights. And there are a lot of different ways people get to the end, whether it's to an agreement or through a contested proceeding or a trial, which is relatively rare that people end up going to trial, even though the court may have made temporary interim orders prior to parents making a final decision or agreement.
Okay. What are some different types of custody orders?
Well, I guess we look at the concept of legal custody and physical custody. And legal custody is a concept that considers decision-making power over a child's health, education, and welfare. And so the court has the power to designate a parent having legal custody on particular issues, although I would say the vast majority of parents have joint legal custody, which means they're both able to make decisions about the children's health, education, welfare. For example, where do they go to school? Do they go to private or public school? Who's the doctor going to be? Are they going to get braces on their teeth? What sort of sports are they going to play? And so joint legal custody assumes that both parents are able to make those decisions jointly or unilaterally without dispute. And there are cases, though, where the courts will decide it's necessary for one parent to have sole legal custody or sole legal custody on specific issues, such as medical care, which is probably one of the more common ones that parents have disputes on these days. Then we have physical custody, which is more often what people think about is where is a child going to be as between the two parents. And we have joint physical custody, which is a situation where a child has frequent and continuing contact with both parents. And then there's the I'll call it the old school of one parent having physical custody and the other having specific visitation rights. What's the difference between visitation as opposed to having joint custody? I don't think there's any particular cutoff. Clearly, 50-50 equal sharing is joint custody. 60-40 probably is, and probably something less than that is still joint custody. And the label isn't always that important. For most folks, it doesn't really make a big difference, other than it makes a big difference to the parents how they feel about the order. So we find most parents either want sole physical custody for themselves or joint physical custody sharing with the other parent.
Okay. Is child custody a difficult issue for a divorce?
It can be. It's probably one of the more difficult issues because it's a very emotional issue, and it's certainly an important issue. A lot of parents put child custody first, and I can say in my practice it hasn't been unusual for people to be almost entirely focused on child custody before they even want to think about the final financial issues, such as dividing stock and bank accounts and selling the family residence, issues like that. It can be a very difficult issue, particularly where one parent wants to move out of the area. So when the divorce comes, people separate. They now live in separate households, not necessarily close to each other, and that can create some serious difficulties and create conflict between parents where each of them think they should be the custodial parent if one of them's moving away.
Yeah, I had a situation that caused a lot of stress for a family because the one of the parents was a resident of Iran, and the other one, the U.S. person, and they split. And I think that the Iranian person had been living here but decided to return home. In this case, it was the husband. And so, anyway, took the kids back to Iran, and then they're having disputes. And of course, Iran is a very male-oriented society. And so, I mean, my son was talking about that. If you're a single woman, your life might be dependent on the decisions made by your brother.
Yeah.
So,
and there's no question, international custody disputes are very difficult. Mm-hmm. And of course, here in Northern California, with the high-tech industry, we have people from all over the world that come to work here. Some of them, temporary on work visas, sometimes with the intent of staying here and becoming citizens. But when divorce comes, sometimes, or not uncommonly, one of the parents wants to go back to their country of origin and take children with them. And those disputes are very difficult.
Right. So what standard applies in making custody order judgments?
Well, the legal standard in the code is best interests of the child. Mm-hmm. That doesn't really tell you a lot, but that really is the standard. And so almost anything might be relevant on determining what really is in a child's best interests. The law does not tell us that there's a presumption or any preference for joint equal custody, but I can say we've come to a point where I think there is a bias in favor of joint equal custody built into the system and the decision makers or the people that prepare evaluations and make recommendations on custody. So I think it's almost become a standard, in my opinion, that joint custody is preferred and a likely result if you have two good parents that they may be different, but two competent parents that live in the same community, it's very likely they're going to share joint custody, maybe not necessarily exactly equal, but perhaps close to it.
Mm-hmm. Okay. So now we'll get into the more unhappy scenario. So when would a supervised visitation apply?
It's become very common at the outset of cases, particularly where we have domestic violence, allegations and restraining orders, or substance abuse by a parent or parents, or allegations of abuse of a child. And so it's not uncommon, perhaps these things precipitate a breakup of a marriage. The domestic violence laws have really, I'll say, expanded over the years since I started in practice, and there are some very significant consequences of having a domestic violence restraining order that can affect the outcome of child custody and visitation rights. It would be very common at the beginning of a dissolution case, if you have allegations, certainly believable allegations that the court thinks are substantiated or have some validity but maybe not finally resolved, that a parent might be subjected to supervised visitation, and that may be very restrictive with a professional supervisor, maybe even at a specific location in a restrictive setting for short term. It might be less restrictive where it could be with friends or relatives, maybe, and the ability to travel with a child, and just about everything in between. The supervision, when it's with a professional, it can be difficult because it's expensive. People don't like to pay for it, and the parent being supervised feels usually that it's very intrusive and express strong objections to it occurring over a long term. So that when there is supervision ordered by the court, there are often some conditions that the supervised parent can meet that might make the restrictions or the supervision less restrictive and eventually have it go away. And that's a pattern we usually see, that normally when there's supervision, it doesn't last forever.
Okay. So how long do these requirements, a supervision type requirement, usually apply? Or maybe, again, it may depend on the case, but you can tell us.
It's certainly going to depend on the case, and it probably depends on the conduct of the parent that's subject to the supervision. So, say there was an issue of alcohol or substance abuse, that parent might be ordered to have random drug or alcohol testing weekly. And if they were to be successful and have clean tests over a period of time, that certainly would help get them out of supervision. Attending AA meetings or participating in mental health counseling that address those issues over a period of time, where some professional says this person has overcome the problem. In the case of serious substance abuse or alcohol, what I'm seeing or hearing from mental health professionals is they want to see somebody clean and sober for a year. That can be a pretty high bar. The court has what they call the Family Court Treatment Program, where they have the person subject to these orders. You have to voluntarily sign up for this. But if you do, you go in and see a judge periodically at the treatment court. The judge hears about the results of your random drug or alcohol testing, hears about whether you're attending AA or what sort of counseling you might be in. And then there's a review process on your temporary custody and visitation orders, where if you're doing what you're supposed to do in the program, I view it as somewhat of a reward. So if you had a very restrictive visitation with your child or children, but maybe after your first quarter in the program you've done everything you need to do, maybe the supervision is terminated or becomes less intrusive.
Okay.
And then at the end of the year, if you've made it through, you'd expect someone would be ready to get their children back in more normalized visitation or a custody arrangement. And that's what I'm seeing happening.
Okay. What input does a child usually have on custody decisions?
Well, the law tells us that when a child is of sufficient age and maturity that they are able to express an intelligent preference, the court shall give weight to that child's preference. What is the age? That's what everybody asks. There's no magic age. I think that most lawyers would say it's maybe around age 12, maybe 10, somewhere in that range. But I certainly could see how maybe intelligent, mature 10-year-old or 9-year-old might have something important to say about their preferences that should be given consideration. And so there isn't a magic age. There's also the age at which if a child wishes to testify in court in a contested proceeding between their parents, the court is required to take that testimony unless they determine it's not in the child's best interest. Mm-hmm. Now, what I've seen since that statute's been around a number of years now, I haven't had a case yet where a child has testified, and all my colleagues I talk to when they've gone to trial thinking that a child is going to testify, judges are very reluctant to let that happen, and they usually find alternatives. In the cases I've had where it was likely to happen, we found an alternative, such as having the child interviewed by a mental health professional to try and determine what their preferences are, and then having that person report the preferences. Or courts, judges can appoint an attorney to represent a child, and one of the duties of a child's attorney might be to determine a 14-year-old or older child what their preferences are, and get that reported to the court and the parties in some fashion, hopefully avoiding having a child testify.
Okay, so they can have input without having to testify, though. So, like you said, you could have the mental health. I always think of the Shirley Temple movies, and then the two parents and they go in with the judge. So, let's just get out of the courtroom. We'll just sit down and talk about this or something. I don't know how realistic that is, but it sounds like they have come up with alternatives to have more informal types of discussions.
Well, and the other thing they say with older children is they'll vote with their feet.
Uh-huh.
And if a 17-year-old really doesn't want to be with one parent and wants to be with the other parent, they're probably going to get their way.
They're just going to walk over to the other one's house and that's it.
Yeah, I mean, it's difficult to enforce with older children, and we see that a lot with particularly teenagers, that they become strongly aligned with one parent and not interested in seeing the other parent, which is really sad.
Uh-huh.
And I've seen those situations a number of times, although surprisingly, I've also seen that the child who's appears to be completely alienated from a parent, often shortly after they reach the age of majority, they go over to the parent that they were refusing to see. Difficult to understand, but
they suddenly flip over.
Yes.
So this sort of leads to our next question, and that's how can a child sometimes make the situation more difficult?
Well, certainly with teenagers that have preferences that some folks might not think are consistent with their best interests, it's very difficult. Their alienated parents often go through a very difficult time trying to find a way to get back on track with a child that doesn't want to see them. It creates stress between the parents. Of course, a parent who isn't seeing a child will often blame the other parent for creating the situation, which may or may not be true. We often have a lot of appearances in court and orders for children or parents to participate in reunification therapy with mental health professionals, which may or may not work, but it can be very expensive as well as stressful for the parents. And then you have to wonder, are we really doing something that's helping this child?
Mm-hmm. Okay. So we sort of talked about this earlier, but maybe you can talk about move-away cases for a few minutes here.
Yeah. Move-away cases are very difficult, and of course here in Santa Clara County, with housing prices so expensive and so many people have moved here because of the employment opportunities for one spouse and perhaps not the other. When the family breaks up, it is often the case that one parent, either by financial necessity, feels they need to move out of this area, or because their family ties or where they were brought up is some other area in the country, even outside of the country, they want to move away. The standard is if there's not an existing child custody order, the standard is best interests. And so we often see these disputes early in the case where the breakup comes and maybe the mother says, I'm originally from Texas, my family's there, I want to move back with the kids. And now you have a dispute. And it's a best interest test. Where we see a lot of litigation is sometimes after a divorce is over and you have final custody orders, which would either be an order that's made by a court after a trial or contested proceeding, that would be final, or the parents choose in their negotiated agreement to designate an order as a final order. In those cases where you have the final order and there's a move away, the law says that the custodial parent has a presumptive right to move with the children. And so the burden somewhat shifts to the other parent. And when does the presumptive right come into effect? It would be where a parent actually has custody. So this would be a case where, say, a parent already had a final order that said they have sole custody, as opposed to joint custody. If it's joint custody, you're going to go back to the best interest test, which is going to put the both parents on a more of a level playing field, at least to start out. But ultimately, it's a discretionary decision by the court if the parents aren't able to reach an agreement.
Wow, okay. So what about, we talked about the situation a little bit where the move away is going to be to a country outside the United States. So have you had experience with that, and maybe do you have some thoughts about it? Or?
I have, and we certainly have situations where there's a concern either the other parent may want to move there, or more often what I see is you have a custody order, but one parent is originally from another country. Perhaps that parent and the children have both U.S. passports and passports from a foreign country, and the parent at least wants to be able to take the children back home, say to Japan, to visit family in the summer, or maybe attend a summer program back there and live with their grandparents, and the other parent has a concern that the children may not come back.
Right.
Those cases are difficult, and negotiating orders to try and protect the parent who lives here in California to make sure the children are going to come back. Those are difficult orders. Sometimes they involve posting bonds, putting in penalties, but they're just very, very difficult. And no matter what you do, there are some countries where if a parent is able to bring the children to a country, the fact of the matter is, unless they're voluntarily returned, you may not ever get them back.
Right.
You know,
So,
not all countries have adopted the Hague Convention, where there's at least a procedure on how to deal with jurisdictional issues and custody disputes between parents residing in different countries.
yeah. That's kind of frightening. So think about that when you're choosing your spouse.
That's true. You know, those are things you have to look at. You know, how strong is your relationship before you have children, and what are those risks, and where are you committed to live? A lot of people don't give thought to those, and when the dispute comes up years later, it can be heartbreaking if all of a sudden, you know, the custodial parent is moving with the children back to Europe somewhere where you're only going to see them maybe a few weeks or months of the year.
Well, like you said, you may not see them again.
Or
I mean, it may not be Europe. It may be Colombia or whatever, you know. So, Wow. Okay. Well, can these orders be modified? Are you stuck if you have an order in place?
Yes, just like child support and spousal support, child custody and visitation orders are modifiable. So if you have an order and you're not happy with it, if it is a temporary order, like we talked about earlier, the standard for modification is a showing of best interests for the child. If it is a permanent order or a final order, then you have a higher burden. You have to show that there's a substantial change in circumstances as well as best interests of the child. These motions are very common. Sometimes they're relatively simple to an outsider. They're as simple as one parent's work hours changed, and so they're able to pick up the child for visitation from school at 2 p.m. on Friday rather than waiting till after dinner on Friday evening, and the other parent won't agree to the change. So an outsider might think those are simple decisions, but when it comes to the parents, they're often, it's a life or death matter whether the pickup is a half hour different from what it otherwise might be, and then the more complicated custody modification proceedings and the move-away situation we've talked about, and just about everything in between, as well as legal custody disputes. Should a child be participating in a particular activity? What if the child's a star baseball player and the other parent refuses to take the child to practice?
Yeah. Mark, we're all out of time, so thank you again for joining me here. Folks, I hope we've shared some information that you'll find valuable. Again, this will be posted at our website, financialinsiderweekly.com, under past episodes. So if you know somebody that's dealing with a child custody matter, you might be interested to watch this. See you next time on Financial Insider Weekly.